I want to welcome everybody to this afternoon's meeting. If you'll just take a moment, bow your head for a moment of silent reflection. And, all right, Mr. Minges.
Good afternoon, Mr. Chairman, Commissioners. Staff recommends next Wednesday, September 26th at 2 o'clock for our next business meeting.
That's good with everyone. That's good.
Okay. Item number 1 on our utility agenda, docket number 2018-14C. It's a request for certification of the use of high-cost universal service funds.
Mr. Chairman.
Commissioner Elam.
Mr. Chairman, we've received annual certification affidavits from the high-cost eligible telecommunications carriers in South Carolina. I therefore move that we direct staff to prepare and file annual certification with the Federal Communications Commission and the Universal Services Administrative Corporation that all carriers receiving high-cost support use the support appropriately in 2017, and that the companies have stated they will use it appropriately in 2019. So moved.
You've heard Commissioner Elam's motion. Are there questions or comments? If not, all in favor, please say aye. Aye. All opposed, no. The motion carries.
Items number 2 through 6 involve gas agreements or amendments to gas agreements, PSC and G that can be taken together. Item number 2, docket 2016-133G. Item number 3, docket 2016-253G. Item number 4, docket 2017-79G. Item number 5, docket 2011-191G. Item number docket number 2017-45G.
Mr. Chairman.
Commissioner Hamilton.
Mr. Chairman, I would take the items together, and for the dockets and items 2 through 6 in regard to the agreements and amendments between SC and G and the companies identified by Mr. Minges, I move that we approve those amendments and those agreements and amendments. So moved, sir.
You've heard Commissioner Hamilton's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Items number 7 and 8 may be taken together. Item number 7, docket number 2015-53E, concerns Duke Energy Progress seeking to amend its tariff for small solar rebate program and large solar rebate program. And docket number 2015-55E, which is Duke Energy Carolina seeking to amend its tariff for the same program.
Mr. Chairman,
Commissioner Urban.
as you heard in the docket number assigned to these two cases, Duke Energy Progress moves to modify its tariff for small solar rebate programs and large solar rebate program to adjust when early termination charges may be assessed. In certain circumstances, such as when a customer has moved or their equipment is damaged by weather, the company believes that eliminating the early termination charge for program participants is appropriate and would result in a more equitable and fair arrangement for its customers. Therefore, I move that we grant these requests, 7 and 8.
You've heard Commissioner Urban's motion. Are there questions or comments?
Chairman,
Commissioner Elam.
did that also include Duke Energy Carolinas?
Yes, sir, it does. Thank you.
Duke Energy Progress and Duke Energy Carolina. Other questions or comments? Not all in favor, please say aye. All opposed, no. And the motion carries.
Item number 9, docket number 2018-124E, Duke Energy Carolinas has filed a motion to dismiss the complaint in this.
Mr. Chairman.
Commissioner Howard.
Thank you. Mr. Chairman, I move that we dismiss the complaint in docket number 2018-124E. Alex has, through his filings, made many allegations against Duke Energy Carolinas, LLC. The issue he raises related to the use of AMI meters do not constitute a claim for violation of Commission rules and regulations. I would note that the company does offer an alternative that would allow the complainant to have non-communicating meters serviced at his address. As to his property damage claim, I am convinced that he can leave I am convinced that we can leave undecided the matter of whether the commission has jurisdictional authority over property damage if occurred related to an electric service issue. Rather, due to the specific relief sought, which is money damage, through the complaint's claim for property damage, that claim is dismissed as well. This commission cannot grant the specific relief sought. The request for money damage is required to be handled by a court with jurisdiction over such damages. So moved, Mr. Chairman.
You've heard Commissioner Howard's motion. Are there questions or comments? If not, all in favor, please say aye. All opposed, no. Motion carries. Thank you.
Item number 10, docket number 2018-164E. Staff recommends that we carry this item over.
Item number 10 will be carried over. Thank you.
Item number 11, docket number 2018-202E. We have a petition to intervene.
Mr. Chairman.
Commissioner Hamilton.
Chairman, I would move that we grant the petition to intervene filed on behalf of Solar First Incorporated. So moved, sir.
Thank you. You've heard Commissioner Hamilton's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
Item number 12, docket number 2017-370E. We have motions for remission pro hoc vici filed on behalf of Dominion Energy.
Mr. Chairman,
Commissioner Urban.
the staff has presented for our consideration the motion for admission pro hoc vici for Benjamin L. Hatch, Esquire, Benjamin E. Humphrey, P-U-M-P-P-H-R-E-Y, Esquire, and Brian D. Schmalzbach. I'll spell that one as well. S-C-H-M-A-L-Z-B-A-C-H. Schmalzbach, Esquire. Filed on behalf of Dominion Energy Incorporated. I move that we grant these requests for admission pro hoc vici.
You've heard Commissioner Urban's motion. Are there questions or comments?
And by the way, they all did file with the South Carolina Supreme Court the applicable fees. That's been checked, and there are no disciplinary matters pending, so they're otherwise qualified.
Any other questions, comments? Not, all in favor, please say aye. All opposed, no. Motion carries.
Item number 13, docket numbers 2017-207, 305, and 370E. We have motions for remission pro hoc vici filed on behalf of South Carolina Electric.
Mr. Chairman,
Commissioner Howard.
I move we grant SC&G's motion for admission pro hoc vici of David L. Balsa, Esquire, Jonathan R. Shiley, Esquire, Julius C. Barnett, Esquire, Emily Shoemaker Newton, Esquire, and Brandon R. Keel, Esquire. So moved, Mr. Chairman.
You've heard Commissioner Howard's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
Item number 14, also in those docket numbers 2017-207, 305, and 370E. We have motions for remission pro hoc vici filed on behalf of the Office of Regulatory Staff.
Mr. Chairman.
Commissioner Elam.
Mr. Chairman, I move we grant the motion for admission pro hoc vici of James E. Cox, Jr., Esquire, filed on behalf of the Office of Regulatory Staff. So moved.
You've heard Commissioner Elam's motion. Are there questions or comments? Not, all in favor, please say aye.
Aye.
All opposed, no. Motion carries. Thank you.
Item number 15, docket number 2018-281E. Duke Energy Carolinas requests that we carry this item over.
Okay. Will be carried over.
Item number 16, docket number 2015-55E. It's a petition to amend filed by Duke Energy Carolina.
Mr. Chairman.
Commissioner Williams.
Mr. Chairman, I move we grant the request of Duke Energy Carolinas to approve the extension of their NEM program until March 15, 2019, and approve the revised NEM tariff. So moved, Mr. Chairman.
Thank you. You've heard Commissioner Williams' motion. Are there questions or comments? Not all in favor, please say aye. All opposed, no. The motion carries.
Item number 17, docket numbers 2017-207, 305, and 370E, is a petition for reconsideration of hearing officer directive order number 2018-112-H, filed by the South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy.
Mr. Chairman.
Commissioner Williams.
Mr. Chairman, the South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy have filed a petition for reconsideration of Hearing Officer Directive Order Number 2018-112-H, which denied the petitioner's motion to bifurcate the consolidated SCE&G nuclear dockets, or in the alternative, to sequence the hearing. I move that the petition be denied for the following reasons. The petitioners state, as they did in their original motion, that rather than having a combined hearing, it would be a better use of judicial resources for the Commission to hold two separate proceedings on the abandonment and merger issues in this case, or to sequence the single hearing. The petitioners further argue that ratification number 285 permits the Commission to bifurcate the consolidated dockets into two distinct dockets and to delay its decision on what the petitioners consider the Non-Baseload Review Act issues past the deadline of December 21st, 2018. The petitioners take issue with the hearing officer's finding that the concepts of abandonment and merger are related and therefore clearly constitute requests made pursuant to the Baseload Review Act, with the resultant requirement that all issues be ruled on by December 21st, 2018. They argue that under the resolution, the company's requests must be made pursuant to the Baseload Review Act, and the examination of the customer benefits plan and other plans connected with the merger proposal is not pursuant to the Act. I believe that the hearing officer correctly noted, as shown in the original Dominion SCE&G petition for approval of a business combination, that the benefits plans under the merger include proposals for rate mitigation for, among other things, abandonment costs incurred by SCE&G. Further, that the original petition alleges that the customer's benefit plan must be considered under two statutes, South Carolina Code annotated sections 58-27-570F and 58-33-280K, the latter statute being part of the Baseload Review Act. Therefore, the hearing officer correctly concluded that the concepts of the merger and abandonment are related and clearly constitute requests made pursuant to the Baseload Review Act. Also, Act Number 258 bars the Commission from considering any requests made pursuant to the Baseload Review Act other than in a docket currently pending before the Commission. Therefore, under the statutes, both matters must be concluded by December 21st, 2018, and there is no opportunity for consideration of the merger matters that would conclude next year. This ground for reconsideration should be rejected. The petitioners also argue, as they did in prior pleadings, that bifurcation would simplify the proceedings and clarify the issues. However, SCE&G and Dominion assert that under either bifurcation or sequencing, witnesses will have to be called to the stand twice, cross-examined twice, questioned by the Commission twice, and redirected twice. The scheduling of expert witnesses will become complicated, as pointed out by the hearing officer. The procedures proposed by CCL and SACE would cause confusion and disruption in the hearing process. Discerning what testimony should be presented in what proceeding or what part of a proceeding would be very difficult, to the point where much of the hearing time could be conceivably occupied with procedural objections. Considering the compressed statutory schedule for the proceedings, it is in the public interest to be focused and efficient on evidentiary issues. That time frame would not provide sufficient time to hold what essentially would amount to two proceedings, whether the hearing was bifurcated or sequenced. For these reasons, I do not agree that bifurcation would bring simplicity or clarification of the issues at the hearing, and I believe that this ground for reconsideration has no merit. Lastly, the petitioners argue that it was not possible for them to raise objections to procedural schedule in January prior to the issuance of the Commission's Order 2018-80, and that revelations since that time make the motion to bifurcate even more appropriate. Although I agree that there have been a number of developments since January, it appears to me that the basic issues of abandonment and merger remain the same. As pointed out by Dominion and SCE&G in documents opposing the original motion to bifurcate more than 6 months ago, after having received motions, comments, and proposals from multiple parties, and after the solicitation of comments from the parties by the hearing officer, the full commission issued Order Number 2018-80. In that order, the commission ordered that the 3 nuclear dockets be consolidated because of the commonality of issues between the dockets, and ordered the adoption of the current procedural schedule. As stated in that order, multiple parties were supportive of consolidation at that time, and in fact, the petitioners were supportive of consolidation of the 2 dockets. No mention was made of consolidating the 3 dockets and then unconsolidating them as to their core issues. Additionally, none of the parties that support the motion to bifurcate objected to the procedural schedule adopted pursuant to Order Number 2018-80. In general, Dominion and SCE&G assert that the motion was untimely. In fact, the 2 companies assert that the petitioner should have sought reconsideration of Order Number 2018-80 within the statutory time frame allowed to request reconsideration or rehearing. Whereas I do not believe that petitioners were required to have sought reconsideration of Order Number 2018-80, other than pointing out that various events have occurred since January, they have not pointed to a specific matter that suddenly required that the abandonment and the merger matters be bifurcated. The question could have been raised much earlier in the process. Accordingly, I believe that the original commission plan as stated in Order Number 2018-80 should be followed. Because of all the reasons I've stated, I move that the petition for reconsideration be denied. So move, Mr. Chairman.
Thank you, Commissioner Williams. Are there questions or comments from commissioners? Hearing none, all in favor, please say aye. All opposed, no. And the motion carries. Thank you.
Chairman, that completes our utilities agenda. Turning to our transportation agenda, items number 1 and 2 are applications that can be taken together. Item number 1, docket number 2018 280T is the application of La Raza Taxi LLC for a Class C taxi certificate, and item number 2, docket number 2018 168T is the application of Top Flight Movers LLC for a Class C household goods certificate.
Mr. Chairman.
Commissioner Hamilton.
Mr. Chairman, I would move that we approve the applications in the docket identified by Mr. Menges. So move, Mr. Chairman.
You've heard Commissioner Hamilton's motion. Are there questions or comments?
Mr. Chairman,
Yes, sir.
I will be voting on motion number 1. However, I did not attend the hearing on motion number 2, so I'm going to be voting on number 2.
So, need to do them separately? We can do them one. Okay, we'll do them together, and yours won't count on number 2. All in favor, please say aye. All opposed, no. Motion carries. Thank you.
Item number 3, docket numbers 2013-141T and 2018-26014 concern request to suspend.
Mr. Chairman,
Commissioner Howard.
I move we grant the request of Sergio Yamalei, Convenient Surge Taxi, to suspend Class 3 taxi certificate number 8725 until August the 30th, 2019. If the application is not ready to begin operation by August the 30th, he must begin the application process again. So move, Mr. Chairman.
Thank you. You've heard Commissioner Howard's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
All opposed, no. And the motion carries. Thank you.
Item numbers 4 through 6 are requests to cancel certificates that can be taken together. Item number 4, docket number 2016-419T, is the request of Venture Transports LLC. Item number 5, docket numbers 2015-361T and 2018-264T, is the request of Peach City Cab LLC. And item number 6, docket numbers 2015-119T and docket number 2018-264T, is the request of Roy Morgan.
Mr. Chairman,
Commissioner Elam.
Mr. Chairman, in items 4 through 6, I move we grant the request for cancellation of certificates in the dockets identified by Mr. Minges. So moved.
Thank you. You've heard Commissioner Elam's motion. Are there questions or comments? Not all in favor, please say aye. All opposed, no. The motion carries.
Items number 7 through 9 are requests to amend certificates that can be taken together. Item number 7, docket number 2010-30T, Lawana A. Pickney, DBA Columbia Shuttle Service. Item number 8, docket number 2007-257T, Betty J. Ross and Sylvia Baxter, DBA Palmetto OmniCoach Transportation Services. And item number 9, docket number 2004-130T, is the request of Kevin James Hampson.
Mr. Chairman,
Commissioner Williams.
in items 7 through 9, I move that we grant the request for amendment of certificates in the dockets identified by Mr. Minges.
Thank you. You've heard Commissioner Williams' motion. Are there questions or comments? Not all in favor, please say aye. All opposed, no. Motion carries. Thank you.
Item numbers 10 and 11 are requests to rescind commission orders that would be taken separately. Item number 10, docket number 2018-240T, is the request of Apple Transportation LLC.
Mr. Chairman,
Commissioner Howard.
item number 10, I move we grant the request of Apple Transportation LLC to rescind commission orders number 2018-507, to authorize the company to provide taxi service. So movement.
You've heard Commissioner Howard's motion. Are there questions or comments? If not, all in favor, please say aye.
Aye.
All opposed, no. The motion carries. Thank you.
Item number 11, docket number 2018-147T, is the request of Graffiti Marketing and Transportation LLC, DBA Cool Bus.
Mr. Chairman,
Commissioner Irvin.
Commission Order Number 2018-316 was rescinded on August 28th, 2018. Should that be 18? Due to the company's failure to comply with commission rules and regulations within the allotted time. An order that has been rescinded cannot be reinstated, so the company must reapply if it wants to provide the transportation service. I would therefore so move.
You've heard Commissioner Irvin's motion. Are there questions or comments? Not all in favor, please say aye. All opposed, no. The motion carries. Thank you.
Mr. Chairman, that completes our business meeting for the day.
Thank you, Mr. Minges. Good job. There's nothing else to come before the commission. We are adjourned. Thank you.